Welcome to Talk Law Radio with attorney Todd Marquardt of the Marquardt Law Firm at marquardtlawfirm.com.
Welcome to Talk Law Radio. I'm Todd Marquardt, on the radio, on Facebook Live, on YouTube, on podcasts everywhere, and on talklawradio.com. Today we're going to be talking about series LLCs, real estate, and estate planning mistakes you don't want to repeat. And you can see, if you're watching on YouTube, that Lexi Law Dog is here with me. Usually she lays down and takes a nap while I do these shows, but today she wanted to get more involved. So we're on the radio Sundays at 4:30 in the afternoon. If you're listening on the radio right now, you already know that. But did you know that we're on the radio on Saturday mornings as well, on 9:30 a.m. The Answer or 6:30 a.m. The Word in San Antonio, Texas. Also, KNTH in Houston, 1070 and 103.3 FM in Houston. So you can find us everywhere if you want to. Now it's time to discover your legal issue blind spots by listening to me and Lexi talk about the law on the radio. And I'm going to be talking about a specific court case that has some lessons for us to learn. But before we get started talking about the law, let's begin with prayer. Dear God, thank you for this day. Thank you for all the gifts and blessings that you give to us. Please forgive us for our sins, for our mistakes, for doing the wrong thing or failing to follow your will. Please help me to give good information to the listeners about series LLCs today. Help us to do everything we do for the good of your people, for our own good and for your glory. In Jesus' name, amen. This is the case of the estate of Richard Lee Bramblett in 2025. That's when it was decided. And it's a big deal because this is the first appellate case in Texas that has had issues about series LLCs. The first series LLC in Texas was filed in 2009, and so it's been 16 years since then. And everybody had theories about how does the series LLC work, and now we have a court's analysis of the statutes that set up the series LLC here in Texas. That's Chapter 101 of the Texas Business Organizations Code, Subchapter M. The cast of characters in this case is Richard Lee Bramblett. He's the father who ultimately passed away. Deborah Bramblett is the daughter, and Edward Bramblett is the son. And in March 2007, Ed, the son, became unemployed and moved into his parents' house to help take care of his mother until her death in 2010. At the same time, Richard and Ed began a small business investing in and managing home rental properties. Ed worked with a realtor and a mortgage broker and located a property to buy. And Richard, the father, he's the individual who bought the property. By 2022, so this was 15 years later, Richard had acquired 7 properties. Ed managed those properties. Sometime after beginning the rental business, Richard established a series LLC and signed the Tall Pines Company Agreement. So corporations have bylaws, LLCs have either a company agreement or it's also sometimes known as the organization agreement. The company agreement dated September 16th, 2011 states that Tall Pines was organized as a limited liability company. It provides that Tall Pines may at any time establish a series by designating members, managers, membership interests, or assets. So a series of a series LLC, think about it like a subsidiary or a baby LLC. The parent company is started first, and then you're allowed to establish subsidiaries after that to sort of separate different assets and or separate different members with different rights. You can do lots of different things with that. Each series established by Tall Pines had a separate right to own, exchange, sell, transfer, exchange, assign, pledge, encumber, or lease for cash, property, or credit, or to partition publicly or privately. Each series also had a power to and capacity to sue and be sued, to make and perform all contracts, to hold title to assets, and so on. And its debts, liabilities, obligations, and expenses were enforceable only against the assets of that series. So this is typical legal provisions that go into a series LLC. I'm getting to the important part. I'm just trying to set the stage for you. In the company agreement, it said assets of series A, B, and C are going to be attached to the company agreement. So from the formation of Tall Pines until the time of his death, Richard held 100% of its membership interest and ownership interest. So he was the only owner. Ed was just like his employee. And Deborah hasn't yet come into the picture. The company agreement reflects that Richard made an initial capital contribution of $2,000 and a capital commitment of $2,000 for an ownership interest of 100 units. Attachment 1 to the company agreement provided that the agreed value of each unit was $20. Among other provisions, the company agreement provided several options for transfer of Richard's membership interest after Richard's death, including the following. Section 14.02 about the death of the initial member said, the provisions of Section 14.03 shall be suspended, and the option period set forth therein shall be tolled for 1 year if the terms of this section apply. To the extent the option set forth in this section is exercised with respect to a membership interest, the terms of Section 14.03 shall not apply. Upon the death of Richard Lee Bramblett, his son Edward Lee Bramblett, if he survives, shall for a period of 1 year have the option to purchase all or any portion of Richard Lee Bramblett's membership interest at the agreed value. Remember, the agreed value was $2,000. On October 19th, 2018, 8 days before his death and in the presence of a notary public, Richard executed special warranty deeds purporting to transfer the 7 rental properties from himself to Series A, B, C, D, E, F, and G of Tall Pines. This is Talk Law Radio. I'm talking about series LLCs in a specific court case involving Richard Bramblett. This is a real case. It's a real Court of Appeals case out of Houston. So hopefully the Houston people have noticed that I have another show that comes on Sundays in San Antonio. You can also find it on YouTube. So you should definitely go to YouTube, search for Talk Law Radio, look for the Lady Justice and the red, white, and blue logo, and click subscribe, and tell your friends how interesting this case was. The issue in this case is whether the transfer of the real estate to Tall Pines LLC by special warranty deed 8 days before Richard's death was effective. So here's the complaint. Deborah Bramblett, the daughter, petitioned the court for declaratory judgment to resolve her disagreement with the purchase of her father's interest by Ed, the son, for $2,000, and whether the transfer of those properties to the series in Tall Pines by special warranty deed was effective. Deborah testified that as of 2020, Richard, her father, had invested about $815,000 in the 7 rental properties. That's a lot of money. He also held mortgages on the properties. Deborah understood Company Agreement Section 14.02 as giving Ed the option to purchase properties for $815,000. So here's one of the disagreements. When I was telling you about the company agreement before, remember I mentioned Section 14.03. Well, she points to Section 14.02, which said that Ed could purchase the properties, not the membership interest. Section 14.03 said something about purchasing the membership interest at the agreed value, $2,000. So the administrator of the estate testified that he had received from Ed 2 checks, one for $200 and one for $1,800, before the 1-year anniversary of Richard the father's death. And so that's when the dispute occurred. Deborah's thinking, well, gosh, that seems unfair that he would pay $2,000 and receive $815,000 in value. The trial court, the district court, ruled that the company agreement of Tall Pines Holdings LLC is not ambiguous. Series A through G of Tall Pines LLC was valid, and the agreed value of Tall Pines Holdings was $20 per unit, and Ed validly exercised his option to purchase the company for $2,000. After a bench trial, the trial court granted Ed's petition for declaratory relief, holding that the transfer was valid, his exercise of the option was valid, and he was the Tall Pines owner. Winner, winner, chicken dinner. Deborah appealed. On appeal, Deborah contends in 4 issues that the trial court made errors in interpreting the Tall Pines Company agreement and in admitting the testimony of Ed's expert witnesses. We're not going to talk about expert witnesses. We're going to talk about Series LLC law. So the law is that Texas Business Organizations Code Section 101.601, a series LLC is a legal entity in which one or more series are established within a single LLC. The Business Organization Code states that in its company agreement, an LLC may, if it wants to, establish or provide for the establishment of one or more designated series of members, managers, membership interests, or assets. So the series LLC was invented in Delaware to own and separate a series of mutual funds. So think of serial numbers when I say series. So 1, 2, 3, 4, 5, or A, B, C, D, E. That's sort of where the concept comes from. The series structure allows a business to partition its assets and liabilities among various series and have different economic arrangements with respect to the different series contained within a single entity. The kernel legal concept of the series LLC is the internal segregation of assets. This was a quote from Adrian Randall Bond and Alan Sparkman in an article, the Texas Journal of Business Law, in 2012. So again, Deborah was saying that all of this wasn't done correctly. It's not valid. I can sympathize with her because Ed and his father, Richard, they didn't follow all the steps that typically needs to be done to create a valid series. there's paperwork that has to be done. There's memorandum, there's minutes, there's assumed name certificates. None of that was done. And so I can see why she would think that the whole thing would fail because it wasn't done correctly. But I'll explain why the court said that everything was valid. So the first problem is that she said there was a failure to include definite terms in the company agreement creating Series A through G. But the court said the series do not have to be set in stone when the company agreement is first executed. Because, remember I said Texas Business Organizations Code section 101.601 says the company may establish or provide for the establishment of one or more designated series. Article 20 of the company agreement expressly provides for the establishment of additional series, stating that Tall Pines may at any time establish a series by designating members, managers, membership interests, or assets. Deborah complained that the transfer of rental properties to their respective series was invalid. Each deed transferred the subject property to an identified series, and after recorded was returned to the identified series. The court said a written company agreement may consist of any one or more agreements, instruments, or other writings, and may include or incorporate one or more schedules, supplements, or other writings for the conduct of the business and affairs of a limited liability company or of a series LLC. So the court said the deeds read together with the company agreement show that each property was effectively transferred into a corresponding series, explaining that a domestic entity has the power to acquire, receive, own, hold, improve, use, or deal in and with property or an interest in property. The court said in any event, Tall Pines was the legal entity that ultimately received the property transfers, stating that even if a series is not created, it's not separate and distinct from the parent company. Deborah next complained that the failure to designate series members renders all series invalid. And the court said no member need be designated to form a valid series. It may be formed with members, managers, membership interests, or assets. Because the statute permits formation of a series with only assets, the lack of a series member did not render any series invalid. So there are some ambiguities in the series LLC law, and this court points out those ambiguities, so the legislature needs to step in and establish some changes in the law so that ambiguities and disagreements like this don't happen. Now, if you're asking me if Richard had been sued and said that one of the renters or tenants of one of those properties got burned alive and it was his fault, he was negligent in taking care of the property, I do think that that judgment creditor would have been able to take him for all that he was worth because of the improper way that he set things up. I think that the liability protection, aside from whether this thing was set up correctly and whether Ed was able to purchase a company with $815,000 in assets for the purchase price of $2,000, whether that is allowed, I think the liability protection is deeply compromised. You should definitely see an attorney before you do something like this. Deborah argued that there was a mandatory termination provision of the company agreement, that it conflicted with the provision giving Ed an option to purchase. And so here's another question. Do you think Richard the father meant for Ed the son, who was unemployed and took care of him and his wife, should get $815,000 of assets from his estate rather than have the son and daughter divide those assets equally. Do you think that Richard, the deceased person, intended to do that? Now, he might have. He might have wanted that to be a reward to Ed for taking care of him and for working so hard on those properties. We don't know the rest of the story. Sadly, Paul Harvey's not here to tell us about all the grief and anxiety that Deborah went through. So I wanted to just point out some more of these problems that come under fire. And so there was a lawyer or a student that wrote an article about this, and I'll let you know who that was in just a bit. But the analysis of this case was a big deal. Like I said, it's the first appellate case about series LLC law in Texas since series LLCs were first allowed to be established in 2009. And so one of the problems is the way Mr. Bramblett tried to create his series LLC and subsidiary series. The way he created it. So I know that he didn't use a lawyer or didn't use a competent lawyer to do this because it wasn't done properly. And so the ambiguities that were created are, what's the legal standard for designating a series and assets to a series? How is it validly, how are property transfers validly made to an unformed series? See that there's just a compounding effect of the mistakes. Was the series created? If not, then how could the properties be transferred to something that wasn't created? And what happens if the series has no members? I was just going to tell you the lesson here is that the court ruled that Richard's attempt to transfer the rental properties to Tall Pines, even if the properties were not transferred to various subsidiaries, they were all transferred just to the LLC itself, the parent company. The default governing body for a series that has no members or managers is the parent company. That's how the court resolved all of this, is that the deeds transferred the property to something, and if the subsidiary wasn't created, then the deeds were transferred to the parent company. Aha! So now we know what happens if somebody doesn't validly create the subsidiaries. And so the lesson here is that you should definitely seek out a business or estate attorney, somebody that has done this before. And I just want to mention our sponsor, Marquardt Law Firm, focuses on business and estate law, including last wills, living trusts, tax-protected inheritance plans, new businesses, old businesses, where you're creating LLCs or series LLCs, where you're establishing contracts and agreements. And we can help those who are facing problems for lack of planning, like in probate court, district court, and county court. If you enjoyed this show, give us a thumbs up. Go to YouTube and search for Talk Law Radio. That way you can watch these episodes and segments while you're washing the dishes, working in the garage, or walking the dog. I'm Todd Marquardt, Talk Law Radio. I'll talk to you later.
This has been Talk Law Radio with attorney Todd Marquardt, brought to you by the Marquardt Law Firm. You can learn more at marquardtlawfirm.com. And be sure to listen to the full Talk Law Radio show Saturday mornings at 11 on 9:30 a.m. The Answer.
Most families don't realize they have hidden legal blind spots until it's too late. wills, trusts, Medicaid planning, even protecting a business. These are the kinds of issues attorney Todd Marquardt helps uncover before they become problems. Todd is the host of Talk Law Radio, where each week he guides listeners through the legal challenges families, veterans, and business owners face, while showing them the practical steps to protect what matters most. Catch Talk Law Radio, Saturdays at 11 a.m. on 9:30 a.m. The Answer, 6:30 a.m. The Word, and now in Houston on AM 1070 and 103.3 FM The Answer, or anytime on YouTube. Planning isn't just about documents. It's about peace of mind, security for loved ones, and building a legacy that lasts. Don't wait for a crisis. Do it before you die.